Probate, it can be the worst. Today in this video, I'm going to be going over what we wish every family knew before going to probate. I think the first thing that I would like to define is what is probate? Probate is a legal proceeding. What does that mean? Yes, it involves a court, the probate court, okay, in the county in which the person passed away in. And that court process is the process by which the wealth and the assets that were in the decedent's name vest in the heirs at law, if there was not a will, or in the individuals that were named in that will that the decedent left behind. Now, what does that mean? Well, it means it can be painful for three primary reasons. Number one, it can be expensive. How expensive? That varies dramatically whether or not it's a contested or uncontested probate. Okay, but it can easily be between $5,000 and $10,000 or more to probate someone's estate, certainly in the state of Tennessee. Second, it's time consuming. How long? That's also a loaded question. But on average, if there is an uncontested estate, meaning there's not fighting, there's not litigation occurring, on average, we're still looking at somewhere between 8 months to a year to probate someone's estate. And then lastly, I would say it's painful because it's public. And for a lot of families, that can be very tumultuous, right? Just having that publicity, having to go to court, everything that's filed in the probate court is public record, okay? You have to give notice to creditors, notice to next of kin. And so that public process can create a lot of stress in the beneficiaries or the heirs' lives. Some of the things that it's really important to know about probate court when it pertains to the time it takes to probate the estate is there's a claims process by which creditors can file claims. That could be hospital bills, credit card bills, ambulance bills, nursing home bills, other creditors, right? And then that process alone takes 4 to 5 months by law to move through. And so that easily takes us into 6 months and beyond just to get started. You have to file an accounting. You shall file an inventory. You have to make distributions. You have to deal with other lawyers, the court, other beneficiaries and heirs. And just that communication and that intermediary process can take us into that 8 months to a year. What does that mean about the estate assets in that time frame? Well, it means that real estate can't be sold typically unless there's a debt or a reason for the court to authorize that sale. And that means that utilities still have to be paid for, property taxes have to be paid for, insurance has to be paid for, and that property has to be protected by the administrator. So real estate can be a real issue. Other assets also are locked up in the estate. And so not only does it take us a year to get closure after death of the decedent, but also those vital assets that we want our family to have custody of are really in a governmental entity's hands, the probate court, during that time frame. Also, families can get wrecked during probate. And the families that get wrecked and get harmed, that get injured in the probate process, are those that did not have a will, that did not have an estate plan. Who are those families? Number one, special needs families. I am constantly getting calls and cases that for relatives that are inheriting from real estate, from farms, from life insurance through an estate, and they're on Medicaid, they're on SSI, they're on SSDI, they're on public housing, they're on SNAP, they're on means tested benefits because of a disability. They cannot work. They also are in a catch-22 because they cannot receive that inheritance. And so we have to go through a lot of legal fees and legal hurdles to set up special needs trust, court authorizations. It can take even longer for those individuals to receive their inheritance in a manner that's not going to strip them of those vital benefits. And so if you are a viewer and you have a special needs loved one, or you are a special needs individual that might have these concerns down the road, talk to your parents, talk to your loved ones to come in and see us. You definitely need an estate plan. This happens in probate though, all the time. I have numerous cases every year in which these fact patterns happen. Other families that get injured and harmed in the probate process can be blended families. Many people are on second marriages from the death of a spouse through a divorce, okay? And they commingle assets, they commingle real estate, they update their spouse on their IRAs and their real estate and things like that. And then they pass away. And then years later, their spouse passes away. And in these fact patterns, only one of those spouses' children are going to inherit, and it's the second spouse to die, okay? And so just to kind of summarize that again, if you have stepchildren involved, if you're in a blended family, you cannot afford not to have an estate plan. That probate court process can be very painful, okay? And so I hope this video has been helpful again, especially for blended families, for special needs families, but just in general. Probate is something that you at least need to be aware of. And if you do select a plan with a last will and testament, at least you should know what is on the horizon and how probate will operate for your family's assets. If you have any questions, give us a call.